Welcome back to One Stop Law. Now, in my previous lecture, I have discussed with you in details all the legal precedents available till date, that is, before the Karnataka High Court came up with its decision on hijab ban issue. Now, incidentally, all the decisions earlier to this were from the Kerala High Court, and I have discussed in details all those judgments in my previous lecture. I will give that link in along with this video as well for your ready reference. And in this video, let us go and understand and analyze the Karnataka High Court judgment on this hijab ban issue, which came on 15th March 2022 in pursuance to the Udupi incident, where a few girl students were restricted from entering the classrooms in pre-university colleges of Karnataka who were wearing hijab. So let's get started with the video and let's see the judgment. Now we come to the Karnataka High Court judgment on hijab ban, the most recent one and the most controversial and debatable one. It was a 129-page judgment, and it is a three-judge bench decision given by Chief Justice Rituraj Avasthi and Justices Krishna S. Dikshit and J.M. Kazi. And after going through the arguments of both sides, that is of the petitioners and the respondents' state, the judges actually framed four specific issues, four fundamental questions the judges framed on which they gave their decision. First is whether wearing hijab or headscarf is a part of essential religious practice in Islamic faith protected under Article 25. Second, whether prescription of school uniform is not legally permissible or as being violative of fundamental rights guaranteed under Article 19(1)(a) and Article 21, specifically under freedom of expression and right to privacy of the Constitution. The third issue before them was whether the government order of the Karnataka government order dated 5th February 2022, apart from being incompetent, is issued without application of mind and further is manifestly arbitrary and violative of Article 14 and 15. And finally, the last issue before it was whether any case is made out for issuance of a direction for initiating disciplinary inquiry against the vice principal, lecturers, and teachers of those colleges and institutions for prohibiting the girls from entering the educational premises. Now, while deciding on the first issue, that is whether right to wear hijab is part of essential religious practice of Islam, the High Court affirmed that secularism is part of the basic structure of the Indian Constitution and that India follows a model of positive secularism. Now, to decide on the essential religious practice or ERP test, the High Court of Karnataka in this case referred to the Supreme Court judgment of Sabarimala case in 2018, and to quote, a religious practice in order to be called essential religious practice should have the following criteria. Number one, not every activity associated with religion is essential to such religion. Practice should be fundamental to religion and it should be from time immemorial. Second, foundation of the practice must precede the religion itself or should be co-founded at the origin of the religion. Third, such practice must form the cornerstone of religion itself. If that practice is not observed or followed, it would result in the change of religion itself. And the final one, fourth, such practice must be of binding nature of the religion itself and it must be compelling. So the Karnataka High Court basically noted that essential religious practice are those which are fundamental to the religion and exist from time immemorial. So by pursuing various extracts from the Quran and commentaries on Islamic religion, the court concluded that wearing hijab has been only recommendatory within Islam. This is because the Quran does not mandate wearing of hijab or headgear for Muslim women, and their penalty or penance prescribed for not wearing hijab. So, because there is no penalty or fine or punishment for not wearing hijab, this is not an ERP. The court also conceded that at the most, the practice of wearing hijab may have something to do with culture but not with religion. So, it was clearly observed by the court that wearing of hijab is not part of essential religious practice of Islam. Coming to the second part of the question number one or issue one, that is on the part of freedom of conscience as part of Article 25, the court stated that no material was placed before us for evaluation and determination of pleaded conscience of the petitioners. They have not averted anything as to how they associate wearing hijab with their conscience as an overt act. There is no evidence that the petitioners chose to wear their headscarf as a means to conveying any thought or belief on their part or as a means of symbolic expression. According to the court, the petitioners merely stated that the hijab was an act of their conscience but did not explain why was it so. So by itself this was not sufficient for the court, treating it as a ground for granting the relief. Coming to the second issue on the right to equality, privacy and freedom of expression, the court said that uniform policy that banned the hijab was not discriminatory towards students and did not affect their fundamental right to expression and privacy. The court further said that wearing a school dress of choice did not form a core part of expression and privacy to such an extent as to apply the test of reasonable accommodation. The court also said that a classroom was a qualified public place akin to courts, and it said that students' demands could not be reasonably accommodated since if they were allowed, there would be two categories of students, one with hijabs and one without. So this will create a social separateness which is undesirable. This would lead to non-uniformity and to a school of not being a safe place anymore. Lastly, the petitioner's contention that the hijab ban discriminated between students based on their gender, since this restriction affected only women students, the court rejected that contention, also saying that the prescribed dress code was neutral and applied regardless of a student's gender or religion and was not discriminatory under Article 14. Coming to the third question on the government's power, the Karnataka government's power to issue the impugned order of restricting students from entering classrooms who wear hijab, the court affirmed the government's power to issue the impugned order by reiterating that Section 133, subclause 2 of the Karnataka Education Act of 1993 did empower the government to issue any direction to give effect to the purposes of the act or to any provision under thereunder. And Rule 11 of the Karnataka Educational Institution Rules 1995 also provided for prescription of school uniform. The power under Article 133 includes the authority of the government to prescribe dress code for schools. So the court anyhow accepted the petitioner's arguments that the contents of the government order uh, give the impression that it had been issued hastily, but at the same time, the court cited executive wisdom and the doctrine of separation of powers to determine that this is too feeble a ground for faltering a policy decision. So, emphasizing on the importance of uniforms, the court said that it was given for institutes to have a power to mandate a dress code. To quote the court in this regard, it said, "No reasonable mind can imagine a school without uniform." Coming to the fourth issue of any disciplinary action being taken against the teachers and principal of the educational institutions on the ground of harassing students, of them not being allowed to enter the classroom while wearing hijab, the court said that since it is legal for institutes to exclude hijab from school uniform, there should not be any action taken against the teachers and principal and vice principal who had asked students to take off their hijabs. The court said that prescription of school uniform would make campuses secular, and it dismissed the demand for disciplinary action against teachers since their alleged acts were in furtherance of seeking adherence to school discipline and the prescribed dress code. The court said, and I quote, "The school regulations prescribing dress code for all the students are one homogeneous class, serve constitutional secularism." Now, if we try to summarize the judgment of the Karnataka High Court, which held that hijab is not an essential religious practice of Islam, it also upheld the validity of the Karnataka government order on banning or restricting students from entering classes wearing hijab, we see that the benches of the view that the insistence on wearing of parda, veil, or hijab hinders women's empowerment and is as such opposed to constitutional values of equal opportunity, public participation, and positive secularism. If I quote the court in this regard, we see that the court has said prescription of school dress code to the exclusion of hijab, bhagwa, or any other apparel symbolic of religion can be a step forward in the direction of emancipation and more particularly to the access of education. This does not rob off the autonomy of women or their right to education in as much as they can wear any apparel of their choice outside the classroom. The court also observed that Mughals or the British did not bring uniform, but it was there since the ancient Gurukul days. The court said that they are of considered opinion that the prescription of the school uniform is only a reasonable restriction which is constitutionally permissible to which the students cannot object to. Now, this decision of the Karnataka High Court has faced a lot of criticism. It has been accepted as well as criticized by different sections of the society having difference of opinion. But many of the experts in the legal field have commented that somewhere a judgment which started as being a very progressive one ended with on a very regressive note, because many feel that somewhere this uniform and this uniform prescription for the school children has got primacy over the right to education of all, or say specifically right to education of children. They say that this judgment creates an overarching framework of reasoning where the sanctity of the uniform is placed above both the goals of education and the exercise of constitutional rights. Many suggest that this judgment could have been put in a better way by saying that even if this is not a part of essential religious practice, but this is a part of one's way of expressing oneself in the way they want to. So freedom of conscience part, we can see that that part is not very well exploited in this judgment, because the court has said the petitioners have failed to give any particular evidence in favor of their freedom of conscience part. So let's see how the Supreme Court addresses the issue, because a number of appeals have been filed in the Supreme Court challenging this Karnataka High Court judgment, and the Supreme Court is very soon will hear this matter. Now, I will not give any of my personal opinion as to whether the Karnataka High Court was right or wrong in giving such a judgment. The Supreme Court is there to take care of the issue. But I would like to end this video on the note of a very celebrated judgment, a very landmark decision of the Supreme Court itself on right to religion or freedom of religion. This is the famous case of Bijo Emmanuel versus State of Kerala. It was in the year 1986, where we see the Supreme Court holding, and I quote, whenever the fundamental right to freedom of conscience and to profess, practice, and propagate religion is invoked, the act complained of as offending the fundamental right must be, I repeat, must be examined to discover whether such act is to protect public order, morality, and health, because the court says it is the duty and function of the court to do so by looking into whether such act actually is against any public order, morality. And you can see the court said, and we must remember this particular line of the Supreme Court itself in this regard, that Article 25 is an article of faith in the Constitution. It incorporated in recognition of the principle that the real test of a true democracy is the ability of even an insignificant minority to find its identity under the country's constitution. This has to be borne in mind in interpreting Article 25. I love this line. And we saw the Supreme Court concluding on the note that our tradition teaches tolerance, our philosophy preaches tolerance, our constitution practices tolerance. Let us not dilute it. So, on this note, I end this video. We truly hope that the Supreme Court comes up with this decision on the hijab ban issue very soon, because every now and then we are getting some controversial news or the other from the Karnataka government or state of Karnataka. Even today, when I am recording this video, we just got the news that the government has come up with the order that they don't want to do any discrimination with students and teachers, and therefore they have issued an order that even teachers wearing hijabs will not be allowed inside the examination halls or inside the classroom. So now the hijab ban, which was earlier on the students, have extended this to the teachers as well. Their argument is that they want to maintain a equality. They don't want to be discriminatory with the students. So we really want a sensible and good judgment from the Supreme Court, keeping every four corner of our constitution and democracy in mind. So let us wait for that judgment. Till then, I will see you all in some next video. Thank you all.